well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. We're going to be talking with attorney Elliot Harding here in just a moment from Charlottesville, Virginia, not too far away from my stomping ground. Major decision out of U.S. District Court in Virginia, where a judge on Wednesday granted class action status to this lawsuit filed by Elliot Harding on behalf of a number of plaintiffs, including John Corey Frazier from nearby Farmville, Virginia, challenging the ban on handgun sales to adults under the age of 21. Now, we spoke with Mr. Frazier not long ago here on this program, but again, we're going to be talking with Elliot Harding here in just a second. Federal judge did not only granting class action status in this lawsuit, but applied a nationwide injunction. Now, he stayed that injunction to give the government time to appeal, but we're going to get the latest details from Elliot Harding here in just 1 second. Before we do, however, there is something else we need to talk about. Biden's America, it's crushing us. You've got companies laying off tens of thousands of workers, one after the other. Americans working two jobs just to get by. Inflation pushing hardworking families to the brink. Just look at the price of lunch meat next time you go to the grocery store. And a digital dollar could be coming down the pipeline to completely destroy our way of life. The truth is, you need a plan. You know it, and I know it. And that is why you should call Goldco. So you can diversify your savings and investments with gold and silver before things get worse. They're a six-time Inc. 5000 winner, 2022 Company of the Year, with thousands of five-star reviews, and they've helped people like you and me place over $1 billion in gold and silver. They're offering up to $10,000 in free silver while supplies last. And if you call them today, qualified callers will get a free Ronald Reagan half-ounce silver coin. So don't wait. Call Goldco at 855-412-3806 today. That's 855-412-3806. Now let's get to our conversation with Elliot Harding, the attorney representing the plaintiffs in this now class action lawsuit, meaning it applies to every young adult between the ages of 18 and 20. Taking on the prohibition on handgun sales to adults under the age of 21. Take a look and a listen. Elliot, thanks so much for coming on the program. Congratulations to you, sir. I know it's not a final victory, but this is still a very big step going forward.
Yes, sir. Thank you for having me back on and for staying on top of this case.
Well, absolutely. I mean, listen, not only is this kind of in my own backyard here with John Frazier, a student at Hamden City in Farmville, but you're up in Charlottesville, Virginia. And this case is of national importance to young adults all across the country. So can you just sort of remind folks what this case is all about?
Sure. So primarily it's about a federal prohibition that's been in place since 1968 on the purchase of handguns from federally licensed firearm dealers by those under the age of 21. And so what this suit stands for is that adults, those being over the age of 18, have a fundamental Second Amendment liberty to self-defense, and they shouldn't be subjected to such an arbitrary age restriction on access to the quintessential weapon of self-defense, that being a handgun. And so the district court in Richmond, Judge Robert Payne, agreed with us and said that the laws at issue are in violation of the Second Amendment. And then yesterday, thankfully, he granted our motion to certify this as a national class action. So we now represent, in this case, now represents every law-abiding, otherwise qualified firearm owner between the ages of 18 and 21.
And that's huge, because one of the problems that we've had in the past in challenging this particular statute is that the plaintiffs age out, right? They can be 18 when they file suit, but by the time, a case ultimately reaches judgment, they're 21 years old, and the government says, well, this case is now moot because they can buy a handgun. Certifying this as a class action status, that takes that off the table, right? Because there's always going to be 18, 19, and 20-year-olds in this country.
Correct. In fact, I previously represented two individuals out of the Charlottesville area in a similar federal case that made its way to the Fourth Circuit Court of Appeals, where the circuit ruled in our favor But about a week or two after the decision, my last plaintiff did turn 21, and the court had to vacate its decision due to it being moot. And so we refiled it with different plaintiffs who were willing and ready and wanted to bring the same style of action. And rather than having to go out and find some organizational plaintiffs such as any group, it could have been the NRA or the Gun Owners Association of America, or several different advocacy groups. We didn't feel like that should be a requirement. It's an individual liberty, and the idea that you can't seek justice in your own individual name just because of, again, the government's unlawful timing restrictions didn't sit well with us. And so we sought the class for that reason, to maintain permanent standing. And thankfully the judge agreed.
Absolutely. Now, the next step here is up to DOJ, right? They can appeal both parts of the judge's order here. They can appeal the injunction that was granted and stayed. They can appeal the class action certification. And do you expect that they'll do that to the Fourth Circuit?
Well, they've already, in fact, the injunction was also granted yesterday, a nationwide injunction for this class. But about 5 minutes later, the judge did understandably, unexpectedly grant the stay of the injunction pending appeal. So the DOJ has signaled that they do fully intend to appeal these decisions. I'd imagine they'll appeal the class decision as well. I don't find that that'll be substantively the biggest issue. Obviously, the merits of the case are what we really are concerned about. And thankfully, the judge did grant a motion to add Corey Frazier's little brother, Justin, who just turned 18, into the suit just last week. And so even if the class is somehow decertified or struck down by the higher courts, we are optimistic that we'll at least have one individual in the matter that should maintain his own individual standing through the course of litigation.
Well, I would hope, given that the Fourth Circuit, again, had to vacate that earlier case because the plaintiffs had aged out, I would hope that would have an impact on their decision in terms of sort of keeping this as a class action, because they understand the stakes here. But I want to go back to the arguments that DOJ raised, the arguments that Judge Payne rejected. DOJ says, look, even though 18, 19, and 20-year-olds can't go into a gun store and buy a handgun, as you say, the quintessential self-defense firearm, they can get a gun through a gift, right? A family member could buy a handgun for them and then gift it to them. There are ways that some young adults under the age of 21 could acquire a handgun. That didn't go far enough for Judge Payne, did it?
No, that doesn't. No, I found that argument not just, well, it didn't sit well with me personally. There's no third-party access doctrine to exercising your civil liberties. Imagine having to ask your parents as an adult to be able to speak freely, or require a warrant, or ask for an attorney. And as I argued in an oral argument to the court, who's to say that the parent is a qualified firearm purchaser? They might be a felon or a domestic abuser or a drug user. They might be the person that the individual is trying to protect themselves from, right? Maybe perhaps a very abusive parent. Who's to say they even have parents, right? And so there's a litany of arbitrary reasons why that type of argument falls apart. Your fundamental liberties cannot be dependent on some third party in that fashion.
Did the DOJ, were they able to muster any evidence that there were longstanding historical analogs to prohibiting adults, young adults, from exercising their Second Amendment rights at some point in the past?
Not based on age. Certainly there were a handful of, unconstitutional today prohibitions on firearm ownership at the time, right? There were restrictions based on race, based on national origin, based on a lot of different factors that we today would never even consider. And as far as age is concerned, no. At the time of the founding, there weren't any. And in fact, we put forth plenty of evidence that, we're not arguing for anyone less than 18 here, because we assume that, and we argue that adulthood is the requisite threshold for fully vesting your fundamental liberties. But in 1791, having just come out of the Revolutionary War, it's not as if those under 18 were the ones that needed those firearms. The entire military was effectively built out of folks 16 and older, even younger, depending on which colony you were coming from. And the founders themselves, several of them at the time of the Revolution, were under the age of 21 when going into war. So to think that the founders expected for an arbitrarily set standard or restriction on adult firearm ownership had no precedent when it came to our founding doctrines.
Yeah, and it's interesting that they're trotting out the, listen, there were laws that disarmed freed slaves. There were laws that disarmed Catholics. There were laws that disarmed all of these groups, right? These classes that were determined to be too dangerous. And yes, these would be appalling today. They would be clearly unconstitutional today, but that's what we're going to rely on to uphold this statute. I mean, if it was unconstitutional, if it's considered unconstitutional today and abhorrent today, if that's the best evidence that they can muster, I mean, it really does show the weakness of their case.
Yeah, it does. In fact, it was an awkward time, I think, during oral argument when Judge Payne rightfully asked, who else, when asking the United States, who else didn't qualify as being part of the people that are being protected by the Second Amendment? And his argument was, do you think that they fall outside of the definition today? Because you have to take it one way or the other. You can't split it and say, oh, well, everybody who was outside of the definition in 1791 is today, but these people aren't. It was, they had to take that position. And I don't pity them but for having to argue it, but part of me, understands that that's a tough stance to have to take, especially when in theory you're representing United States of America, which is supposed to be protecting your civil liberties.
That's right. Absolutely. So what's the next step for you in this case, Elliot?
Literally today, going to be filing some follow-up documents with the court. I would expect within the next couple weeks, the DOJ will file their notice of appeal after a final judgment is entered. There have been final orders, but there's one final judgment that has to go in before the appeal can be submitted. And then we'll just start the clock to the Fourth Circuit. I'm hopeful that the Fourth Circuit will just take this case en banc, meaning all 15 judges will hear it rather than us having to go to a 3-judge panel first. That will hopefully expedite this process so that it doesn't drag on unnecessarily. And I'm optimistic that they'll do that because they did already consider it once in the Hirschfeld case. And now that we have a nationwide class, it should raise it to such a degree of importance that they would hopefully grant it just being a one-time full circuit hearing.
Yeah.
That's our hope.
All right. Well, fingers crossed that that is indeed the case. We'll be following up with you again in the near future because, we are going to keep a close eye on Frazier v. ATF. But again, congratulations on an important victory. And we'll see what DOJ has to say going forward. But Elliot Harding, thank you so much for coming on the program today. I appreciate Elliot joining us on the program and looking forward to giving you more details here in the very near future about Frazier versus ATF. Right now, let's turn our attention to today's Armed Citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Los Angeles. Suspect in a South Los Angeles crash that killed 3 Uber passengers was out on probation for attempted murder. That's right. And now facing even more serious charges. The suspect, according to ABC 7, 31-year-old Gregory Black, now facing 3 counts of vehicular manslaughter after a 2-car crash this past weekend. Black also faces allegations of 2 or more prior felony convictions, as well as aggravated circumstances of great bodily injury, according to DA George Gascon's office. Black pleaded not guilty to his arraignment on Tuesday. He's due back in court next week. According to Los Angeles Police Detective Ryan Moreno, Black is a, quote, well-known local gang member, and at the time of the accident was serving a 5-year probationary sentence for attempted murder. Moreno said that the Black's past includes 11 felony bookings, as well as 3 prior convictions, adding that Black had 2 strikes against him, including a, quote, super strike under California law, which raises the question, why on earth was he given probation for attempted murder? Well, the answer might lie in George Gascon's sentencing policies, although the DA so far has remained pretty tight-lipped about this. The DA, or a DA's office statement, says that Black was placed on probation, quote, following a careful review of the evidence in that case. Well, if the evidence was enough for a guilty plea for attempted murder, then why wasn't the evidence strong enough for, I don't know, any time behind bars, especially given Mr. Black's previous criminal history? Again, don't know the answer to that question, but I suspect that a lot of it has to do with the underguiding philosophy and ideology of the head of the L.A. District Attorney's Office, George Gascon. Today's Armed Citizen story from Nashville, Tennessee, where police say no charges have been applied in a shooting at an auto shop in Antioch. The Nashville Metropolitan Police Department investigating that case started apparently a Wednesday night. According to the Metropolitan Nashville Police Department, a 33-year-old man drove to a Valvoline instant oil change station around 11:30 Wednesday night and asked if somebody could help him put air in one of the tires in his car. No one was around to assist him, so he started using the hose himself. One of the employees of the shop, Terrence Smith, 22 years old, told the man he's not allowed to do it and then took the hose away from him. The man began arguing with Smith, which prompted the manager, 32-year-old of Brooklyn Key, to instruct the man to leave. The man then punched Smith in the face. Smith pushed the man back. That's when a fight began. Police say that the manager then retrieved a pistol from his vehicle, returned to the 2 men who were fighting. The employee pushed the man into the driver's seat of the car and then turned to walk away. Like, okay, you're in your car, you're done, get the hell out of here. That's when the man grabbed a gun from inside his vehicle and started firing. The employee was hit in the arm and the hip. And when the manager saw this, he fired 1 shot at the man, striking him in the head. The man pronounced dead at the scene. The employee of the store transported to the hospital, listed at last report in stable condition. The police department reported that the man's gun was taken from the scene by an unidentified man after the shooting. So apparently somebody just strolled up, took the gun, and then walked away. So far, no charges have been filed. Self-defense claims are being investigated. But right now, if the evidence is as the narrative suggests, this would be a clear-cut case of self-defense. So we will keep our eyes on the story, bringing you more details as they become available. Finally today, our good deed of the day, in the right place, at the right time, willing and able to do the right thing in Pennsylvania. Neighbors who helped to rescue a Pennsylvania woman from her burning home. This was in Cole Township. 18-year-old Curtis Lahr is being hailed as a hero after he ran to the woman's rescue and was able to save her life, again, from that burning building. New York Post reporting. Lahr said it was just surreal, like all in the moment. I don't know. I was just running. I didn't have any shoes on. I was just trying to help the lady. He grabbed a ladder nearby, handed it off to neighbors who placed it against the back of the home where the woman was trapped on the second floor. Lahr said he could feel the heat from the flames as he handed off the ladder, saw broken glass shooting out of the home. He said it was hot. I mean, in the moment, I didn't even realize how smoky and how hot it was back there, but it was pretty intense when you're that close to the fire. So after running barefoot to the home, grabbing the ladder to save the woman, she was able to climb out of that second-story window, down the ladder to safety, apparently covered in ash from the blaze, taken to a local hospital, but she is expected to be okay. Lahr said her hair was burnt off. She was, again, covered in ash, but no life-threatening injuries, thankfully, because of the quick thinking and the fast actions of the woman's neighbors, starting with 18-year-old Curtis Lahr, in the right place at the right time, willing and able to do the right thing. We thank you very much, and a tip of the hat to that young man. Now, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program. As always, I will not be with you next week. But we'll pick things back up again in just a few days. We will have the latest Second Amendment news and information still posted at bearingarms.com in my absence. So I would encourage you to check out the website. If you like what you see, you can always become a VIP or VIP Gold member. Just go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. As our way of saying thanks for showing your support, we're going to give you exclusive content you won't find anywhere else. News stories and analysis of the matter, just like the support that you've provided. So thank you again. Enjoy your weekend, and until we talk again, be well, be safe, and be free.